Everyone, make sure you're muted, please. All right, everyone, thank you so much for your patience. We are starting a little bit late. I know we're supposed to start at 2 p.m., but we're starting at 2:05 p.m. We had other court matters that we had to clear up with our contested hearing that is now not contested. So Michael Sawyer, let me start with you.
I am reporting back to the court.
All right, thank you. And who's your client, Mr. Sawyer?
From this morning, Your Honor, Jacob Tafoya, and we did not get a response. He was a no-show, but we found out where he's at.
Oh, where is Mr. Tafoya?
He is in the downtown Methodist Metro Hospital on McCullough. Seems someone beat him up last night, and we got the verification of where he is at.
All right, so do you have any idea as far as when he will be available to appear?
Judge, I would say no more than a few days, a week tops. He's not near life or death. He just got beat up real good from what his mom said.
Okay. Norma, on Jacob Tafoya, can we reset this for 2 weeks?
Yes, ma'am.
If I may,
Yes.
that's 99% sure that will be a plea. We've really worked it out with the state already.
All right. What date will we come back, Norma?
June 2nd.
All right, is June 2nd a good date for you, Mr. Sawyer?
Anytime to see you, Judge, is a good day for me.
Oh, you're so sweet. Thank you. Tell your brother I said hi.
We'll be in town this week. Have a good day, Judge.
All right, thank you. Okay, and then we have Suzanne Kramer.
Yes, Judge. Norma sent me the paperwork over lunch, so I just need to, one of them is the certificate of appeal and I think, and the video conference. So I just need to go into a breakout room with Tito Jacobs to get him to sign it.
All right, I'm going to send you to breakout room number 2.
Thank you, Judge.
And Mr. Jacobs, if you could go to 2, please. All right, Ed Piker.
Yeah, Judge, same situation. We've gone over everything and signed everything. Still waiting on the video conference consent and trial certification of appeal. Once we get those signed, we're ready to go.
All
Mr.
right.
Becker, I tried calling your office. Nobody answered. I even chatted. No one.
All right. If you guys would go to breakout room number 7, and Ms. Ferguson, I have you in number 7 with Mr. Piker. And Mr. Piker, if you could go to 7, please.
Thank you.
Thank you. Tricia Padilla, where's your client?
Did you really take your phone?
Can you hear me, Judge?
Yes.
I have not heard from my client since first thing this morning. He stated he was at work and was going to try to take a break. I know he knew that the plea was ready and it was recalled for today. I've called several times in text and I have not heard from him. What does the court want me to do?
What is your client's clause number, please?
Yeah, it is. Hold on one second and I will get it. It is 2021 CR 2982 B as in boy for Mark Anthony Moreno.
All right, just one moment. All right, on Mr. Moreno, I'm going to recall this for tomorrow. I'm going to note that your client did not appear. If your client is not here tomorrow, we're going to have some issues.
Okay, I will let him know.
All
May I
right,
be
so,
excused?
yes, it will be at 9 a.m.
Okay, thank you.
You're welcome.
Bye-bye.
See him there. Awesome.
All right, and then the person who's here on Mr. Villegas, that would be Bill Simmons. Bill
Yes, Your Honor.
Simmons. Yes, sure. Your client is in the courtroom.
Okay, Judge. And what we had, Judge, was we had a offer was tendered, conveyed that to my client. He'd like some time to consider that prior to us putting that on the trial docket. So I told him we would request that from the court.
To the courtroom, can I have Mr. Davis Villegas, please?
Yes, Your Honor. You can see yourself on top and it's the camera that with the green light.
Mr. Villegas,
Good afternoon, Your Honor.
good afternoon. Why are you in the courtroom as opposed to Zoom?
Because I didn't follow the instructions that were given by the judge, but I don't want to make any excuses. I really got lost in the moment, and I'm so sorry. I know you're live on YouTube, and it was an accident. I was at work and
No, it wasn't an accident. It was a choice, right?
Yes, ma'am.
Okay. So that had better not happen again. If it happens again, you are going to be required to appear in court every single time. Do you understand?
Yes, Your Honor, I understand.
Now, your attorney is telling me that an offer has been tendered to you and you want a chance to think about that?
Yes, Your Honor.
Okay, so I'm going to give you a chance to think about that. Mr. Simmons, is this a complicated case?
Your Honor, I would say it's a 2-count indictment. It's a family violence case. Complicated, substantively, no, but in terms of whether or not it's possible that this could go to trial.
All right. And when I say complicated, I guess really what I mean is complex. Do you have all the discovery?
I feel comfortable saying that I have the discovery, Judge, but I mean, we will want the witness list, but that'll be, well, it's already been requested. But outside of that, I think I have most of the discovery.
All right. Ms. Ferguson, can you give Mr. Villegas a 30-day reset? And that will be your plea deadline date, Mr. Simmons?
I don't know. That's what I'm trying to.
So Mr. Villegas, after that date, well, at least on that date, you've got to let me know whether or not you want to accept the offer that's been extended or not. That's completely up to you. So I'll know whether to put this on the trial list. Do you understand?
Yes, Your Honor.
And if you decide that you wish to go to jury trial or have a trial, then there needs to be a discussion. And Mr. Simmons, if you can discuss it with the state, whether or not you want a bench trial or a jury trial. And if you could discuss that with Mr. Villegas, if that's his decision. So Norma, what day will we be coming back on Mr. Villegas?
June 29th.
All right, Mr. Villegas, we'll see you back on June 29th. I'm notating that we had issues with you on Zoom, but I will allow you to appear by Zoom, but don't cause any more problems on it, okay?
Yes, Your Honor. There will be no further problems.
All right, thank you, Mr. Villegas. They're gonna give you a reset date, so you'll have it with you, okay?
Thank you, Your Honor. You have a beautiful day.
All right, thank you. That is the first beautiful day I've been wished. Take note, Brenna.
Have a beautiful day, Your Honor. May I be excused? I'll be the
Oh,
second.
you are so, Bill Simmons, you're just too late, but thank you. I don't even know if that's coming from your heart right now, but I'll accept it. Have a beautiful day. Tell your mom I said hi.
Oh, well, thank you, Judge. May
All
I be
right,
excused?
yes. All right, Mr. Bain, and then I'm going to take up Mr. DeWiggins. Mr. Bain, who is your client?
My client is Ray Gomez Beltran, and I did see him on the screen a little while ago at the jail.
All right, let me see where he is.
I'm here.
Oh, thank you. All right. Have you had a chance to speak with him, Mr. Bain, and finish the paperwork or no?
I'm not sure. I hope that you have the paperwork. So
did the paperwork.
Okay, what I'm going to do is I'm going to send you to breakout room number 1. And Mr. Gomez Beltran, I'm going to send you to 1. And I'm going to send the clerks to number 1 so they can let you know if they have the paperwork. If the clerks could go to breakout room number 1, please.
Thank you, Judge.
All right, Mr. DeWiggins.
Yes, Your Honor.
Yes, your client. What's his name?
Benson.
All right, what is happening with Mr. Benson?
He would like to accept the state's agreement on the MTR, except he's being evicted from his home. And he is afraid that if he goes to SADF right now, all his 20 years worth of accumulated property will be taken out of his home and he will lose everything and be at a place where he's starting completely over when he gets out. So he's requesting a 30-day PR bond to take the valuables out of his home, take him to his mother's house, and then return for SADF.
Have you talked to the state?
Yes, Tom is against it.
Okay, so
We're agreed on what the MTR result is, but Tom does not agree on letting my client out to take care of his personal situation.
okay, let me wait till we get Mr. Benson on the screen because I don't see him on the screen. So as
Neither
soon as he comes back on the screen, I'll take that up.
Thank you, Your Honor.
Sure. Dan Rodriguez, who are you here for?
Eduardo Riojas Mejia. Norma said there was a motion that you wanted heard today.
Which motion is that, Ms. Ferguson? You're muted.
Yes, the motion to withdraw, Judge, that you had.
Oh,
asked
okay.
me that. And the interpreter is here. Ms. Abrams is here.
The attorney is the prosecutor is Oscar Salinas.
Salinas. All right, could someone have Oscar Salinas zoom in, please, for us to hear this motion?
Yes, Judge, I'll reach out to him right now.
Thank you. All right, Linda Corley.
Yes, Your Honor, we are here.
All right, and who's your client?
My client is John Klosner. We're here on the violation report, and the complaining witness, Carissa, is also with us, Carissa Wilburn. And I have also conferred with Joe Ray.
All right, and so on the witness, who is your witness?
Carissa Wilburn, she is the complainant, and she is the one involved in the no contact order.
Okay, is she going to say something different?
Judge, no, I just some explanation about where they were during the in-person violation. I wanted to have her here just in case you needed her, and she was willing to do that, but I can go through all that with you. I've talked with Joe Ray about it as well.
Okay, just one moment. All right, so it had to do with the violation report.
Yes, Your Honor, violation of a no contact order.
Okay, your client is supposed to be in the courtroom. Is that correct, Ms. Ferguson?
I just got the email last night at 4:20. I didn't see it till this morning, and I didn't notice it saying that he needed to be there in person. I'm sure we can do that.
No problem. We'll do it now.
Okay, thank you, Judge. I'm sorry if I misunderstood that.
That's okay.
Could I get a breakout room with Mr. Riojas Mejia?
Just one moment.
Thank you.
I'll send you to breakout room number 3. Do you need the interpreter in there, Mr. Rodriguez?
No, I'll go in there without the interpreter.
I just looked at the email. It didn't say he needed to be there in person, but certainly if that's what the court prefers, I'll try to do that in the future.
Oh, no problem. Everyone, just give me one moment, please.
John, you're going to be required to have your camera on.
All right, the court is calling Night Mag number 593301, State of Texas versus John Klosner. Could I have parties announced for the record, please, for the state,
Joey Garcia for the state.
for the defense?
Linda Corley for Mr. Klosner.
All right, and Mr. Klosner, could you unmute for me, please?
Yes,
Are
ma'am.
you John
Can you hear me?
Klosner? Yes. Are you
Yes,
John Klosner?
yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Klosner, do you have any objections to this hearing taking place by video?
No, I do not, ma'am.
All right. Court is in receipt of a violation report from pretrial services. Have both the defense and the state had a chance to review that violation report?
Yes, Your Honor.
All right, so there's a violation report. What the allegation is that the defendant is continuing to make contact with the complainant. And the court is in receipt of letters that are said to be written by Mr. Klosner to the complainant. State.
Judge, I conferred with defense on this. I believe there's an explanation or some type of reasoning for the no contact in person. There is an agreement to continue on his current bond conditions that he's on with admonishment of the court.
Okay, so defense, what is the explanation for this defendant writing letters to the complainant?
Okay, so Judge, I think Joey was referring to, there's another violation for May 13th of in-person contact, and that's the one that we're talking about. I think the letters that were back in December, they happened quite a long time ago. That was a definite lapse in his judgment, Judge, and there's no explanation other than bad judgment. On the May 13th contact that occurred, Mr. Klosner got a extended stay motel room. It's in his name, and that's where this contact occurred. And Ms. Wilburn, the mother of the child that's in the no contact order, she was living in an apartment and she was thrown out of the apartment, and she came to Mr. Klosner's extended stay. She had their newborn, who was just born on the 10th, so was only 3 days old, with her. There were no contact orders for the child at that time, just for the mother. And so he did allow her to come there. And then on that day, the CPS did go to visit her on an unannounced visit to her apartment. And she wasn't there. So they called her and said, well, where are you staying if you were thrown out? So she gave that address as her residence, and they came there to his motel room. And then he, I guess, panicked and got into the closet, Your Honor. They were in a bad situation. It has since been remedied. She is now living with her mother, and CPS has also put together a safety plan providing for visitation with Mr. Klosner, I believe, at Kid Share, or that type of facility is what was described to me by Carissa. And she's staying with her mother and has a number of people that are supervising her with the child as well. So we have, Judge, we have remedied it. I think it was extenuating circumstances on the in-person contact, and there's no explanation for the letters except for a big lapse in judgment, Your Honor. And we had requested the no contact order to be changed to no harmful or injurious. We have a affidavit from Carissa. We have her here now. And I think we might have had her at a previous one, but unfortunately the court did deny changing that at the last hearing. I would request if you would consider allowing him to have contact, no harmful or injurious contact with Carissa. At this time, I do believe that the state is opposed.
All right. The court is not inclined to let him have contact with her. I mean, we are here And Mr. Klosner, I want you to understand, I don't take any of these allegations as true because I haven't heard any facts, right? So I'm just dealing with what I have in front of me at the time. And what I have in front of me at the time is that you're charged with assaulting a pregnant person. And that person is alleged to be the person who is here on the screen listed as Carissa.
Yes,
Now,
ma'am.
so counsel, are they allowing him to have contact with her in CPS court?
I don't have all the details of that, and I haven't seen all the safety plans, Judge, but when I talked to Carissa, she did indicate that they have put in place for him to have visitation with the child. I think they're just, I don't know if they've made any orders about John and Carissa having contact without the child around. But I know they want to work for reunification, so at some point, I know he will be doing services, and they do want to get their family back together and on the right track. I have also talked with Joe Ray, and he's reviewing some records so that we can get a plea offer and try to get this case resolved as well, Judge.
All right, Mr. Klosner,
Yes,
are you
ma'am.
still on GPS?
Yes, ma'am, I am.
You're
GPS.
on tracking only right now,
Oh,
Judge.
excuse me. I'm sorry. Excuse me, Judge. I'm sorry. Tracking. Yes, ma'am.
No problem. Okay, Mr. Klosner, there is something you have to understand. You're
Yes,
not
ma'am.
allowed to have contact with her.
Yes, ma'am.
You know, I understand what everybody is saying, that she came knocking on your door because she had these issues. She's
Yes, ma'am.
gonna have to start knocking on somebody else's door.
Yes, ma'am. And I'm just trying to do the right thing. I'm trying to get my life back
No,
together
here's the thing.
and working. And okay.
Time out. So you need to talk to your attorney about what needs to be done if she comes knocking on your door again.
Yes, ma'am.
Because I have a feeling, I could be wrong, but I have a feeling she's going to come knocking on your door. But I do know that with Child Protective Services cases, because I've done plenty of them, if they have a no contact order and people are violating that no contact order, then more likely than not, you're going to be headed for a jury trial seeking to terminate parental rights. So I'm telling you, the order in this court is you are not to have contact with her.
Understood.
And the person who's listed as Carissa, if there is contact with Mr. Klosner, there's going to be an issue. So, and we're off the record for a moment. Here's the thing. I don't have any jurisdiction over the complainant in this case. It sounds to me like both of you all should be working your CPS service plan and working on each other as individuals before anything else is decided. And I'm going to help you all do that by saying there is to be no contact. And the person who turned these letters over, everybody can read it because it's in the violation report. Her mother is the one who turned these letters over. So that means that her mother is in her life. I'm assuming her mother cares for her. So if there's an issue, she can pick up the phone, call her mom. She can pick up the phone and call her CPS worker, because there are a lot of programs out in the world for people who have children who are losing their home, losing a place to stay. And I know for a fact that when you're involved with Child Protective Services, they provide a home, they provide food for your child, they provide a babysitter for your child. All of this is free for a year. And when I say free for a year, I mean taxpayers are paying for it, but the people who are working the plan to become hopefully better parents for their children and in a better relationship with each other, they're not paying for it. We're all paying for it. So, Mr. Klosner, we can go on the record. I want you to hear me and hear me clearly, so there's no confusion.
Yes, ma'am.
You are not to have contact with her. Your attorney will tell you, and I'll get a chance for you to talk to her. She will tell you what you need to do if Carissa comes knocking on your door.
Yes, ma'am.
Because otherwise, if you voluntarily have contact with her, there are other options for me to consider on this order. And those options are increasing your bond, which means you'll have to make another bond, putting you on full house arrest, which means you can't work. You're going to be at your house or wherever you live 24/7. or remanding you without bond, which means you'll be at the Bexar County Jail until you hear your case. You understand?
Yes, ma'am.
So to every action, there are consequences. So you've got to make good decisions. Do you understand?
Yes, ma'am.
So what I'm going to do is I'm going to note on here that you've been admonished, and we will continue with the same previous conditions that have been ordered. All right, is there anything you need to say to me, Mr. Klosner?
I am sorry for my actions, and this will never happen again. Yeah, my word on it.
All right, thank you.
Yes, ma'am.
Defense, anything else?
Nothing from defense, Your Honor. Thank you.
All right, thank you, Ms. Corley, for coming. Thank you, Carissa, for coming. Joe Ray, do you need to speak to the complainant before she signs off?
Our office spoke to her recently, Judge. Not right now.
Okay. All right, thank you. All of you are excused. Thank you so much for coming.
Thank you, Judge.
Thank you, ma'am.
Thank you. And who are the parties on Tito Jacobs? Tito Jacobs.
I am, Judge.
All right, who's the prosecutor?
I was dealing with Marcus, I believe.
All right, is your client still in a breakout room, or is he?
He could.
Yeah, he's in breakout
be,
room
Judge, yeah.
number 2.
Okay.
To the clerks, could you go to breakout room number 2 and have Mr. Jacobs leave breakout room number 2, please?
Yes, Judge.
Thank you. Brenda, it feels like it's a Friday. I know it's a Wednesday, but somehow it feels, my go-to is it feels like a Friday. I never say it feels like a Monday.
Oh. You're just keeping it real, Judge, keeping it real.
Oh, that's what we have to do. Mr. Cox, who do you have?
I appreciate it. Well, Judge, I have a straggler, and I just want to talk to one of your family violence prosecutor, if possible.
What is your client's name?
Her name is Terrell Shirley, with a cause number of 2020 CR 7215. Keeping it real. I like it. When I come here, I like it because it's just real when I come here, I feel, I can, I just feel something, just, I feel encouraged, it's so real.
All right. Okay, Mr. Cox, I'm going to send you to breakout room number 1. And could somebody from family violence go to breakout room number 1, please? Happy Friday. All right. Could I have parties on mute, please? Court is calling 2021 CR 0015W, State of Texas versus Tito Lee Anthony Jacobs. Could I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Suzanne Kramer.
And are you Mr. Jacobs? Mr. Jacobs, could you unmute for me, please?
Yes, ma'am.
Are you Mr. Jacobs?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No, Judge.
Mr. Jacobs, I'm showing you a document entitled Defendant's Consent to Appear by Video Conference. Did you review that with your attorney? Did you understand it, and did you electronically sign it?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Judge.
Are you the same Tito Lee Anthony Jacobs who was placed on community supervision in 2021 CR 0015W for the offense of burglary of a building on January 8th, 2021 for a term of 4 years? Is that you?
Yes, Judge.
All right, state.
Condition number 5, on or about the 12th day of February 2021. In Bear County, Texas, the defendant, Tito Lee Anthony Jacobs, did then and there fail to attend orientation at the Bear County
I was working at
and Corrections Department
the
in
store.
violation of condition number 5.
All right, Mr. Jacobs, unmute. How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 5, the court can find it true, grant the motion, sentence you up to 2 years in the state jail
Yeah,
facility,
something like
and
that.
up to $1,000
But it was
fine? Did
only
you
like,
understand?
well, I used to work
Yes,
8
Judge.
hours.
Knowing that, do you still wish to
Used to work
plead
8 hours, but not, but. I
to
started
violation of
working-
condition
started
number 5?
slowing me down because like COVID was
Yes.
coming in.
All right,
So
court
I
will
started
find
working like
violation
4
of
hours
condition
a
number
day,
5 true.
4
Is
or
there an
5 hours
agreement?
a day.
There is, Judge.
Yes,
All right,
Judge. We're asking that you grant the motion, revoke his probation, reform the underlying to sentence him under 1244 to 180 days in the Bear County Jail.
That is the agreement, Judge. And by my count, as of this morning, he has 71 actual days.
And I'm sorry, you said 180 days?
Yes, Judge.
All right, Mr. Jacobs, could you unmute?
Okay, yes, ma'am.
Are you asking me to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
Why should I follow this agreement? You did nothing. You got on probation and you disappeared.
Yes, ma'am, I do understand that, and I do apologize. I was not in the right state of mind. I was doing things I wasn't supposed to do, and
What does this mean? You're saying things, but you're not telling me anything.
I was doing things I wasn't supposed to do. I was not. I went back to using drugs again, and I wasn't supposed to.
Okay, I'm gonna have you speak up.
I have to save too, in case of emergency.
So what did you say?
I do take the bus too.
I had,
try to look for help.
I
in
went
other
back to doing the
places.
same thing I was doing before. I just got
That's
scared
what I've
and
been doing this time.
I didn't
when was
report. And I do apologize. It was a mistake. I should have went.
out.
So how are you planning on making your life different if I were to go along with this? Because that means that you'll be out of jail after you serve your time, and then you'll either pick up another offense or you'll get your life together.
I will get my life together. I had
How?
I had rolled myself into Haven for Hope before I was arrested, and I was working on getting my housing, getting different kinds of help.
63 and 58, my dad.
All right, do you have children?
Yes, ma'am.
What are their ages?
She's 12 years old.
We went back to Mexico.
Are you in her life when you're not in jail and not doing what you're supposed to do on probation?
Yes, ma'am.
And are you in her life when you're doing things that you shouldn't be doing?
No, ma'am.
Here's the thing, children are supposed to be able to look up to their parents, and right now your daughter can't look up to you because you're not doing things that she should try to emulate. Do you understand?
Yes, ma'am, I do. She's mad at me right now. I do understand it.
Yeah, and see, isn't that a shame that a daughter is mad at her father and she's only 12? And the reason why she's mad at you is because you're doing things that result in you being in the Bear County
The last time I
jail.
got from
Yes,
prison, I
ma'am.
got out of.
Need to
prison.
change your ways. All right, I'm gonna follow your agreement, grant the motion, revoke you, sentence you under 1244 to 180 days in the Bear County Jail, give you credit for any time served. I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did
Yes,
you
ma'am.
electronically sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to
Yeah,
appeal,
but
you do
they're
not
not-
have
they're
the
not
court's
interested.
permission to
Knowing about
appeal.
that.
Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Good luck to you, Mr. Jacobs.
Thank you,
ma'am.
Judge. May we be excused?
Yes, Mr. Jacobs,
Yes, ma'am.
did that neck tattoo hurt?
It did hurt, but it was well worth it. That's my daughter's name.
Do you not remember your daughter's name unless it's tattooed on your neck?
Michaela? Yes, ma'am.
Yes, but I mean, do you need to have it tattooed on your neck in order to remember it?
It's a reminder of every day I look in the mirror. It
I know I keep going back to the same thing, but it hits me every time I see that name.
All right.
It's my only daughter.
So when it was painful putting it on, did you decide to stop after one letter? Were you thinking about stopping and saying, I'll just do with an M? Or did you say, I'm in it now, got to finish it?
Yeah, the whole thing. I'm in it now. So.
All right. All right. Good luck to you, Mr. Jacobs. Do better. Otherwise, you're going to end back and forth in the jail, and you're going to look up. Your daughter is going to be like 16 and not really know the Jacobs that you can be. Okay.
Thank you, ma'am.
All right. Good
Thank
luck
you,
to
Judge.
you. Thank you. Norm, can you let them know that 14E can go back?
Good afternoon, Judge.
All right. And then who are the parties on Victor Rodriguez Vasquez?
Ed Piker for Victor.
No, man, at all.
Joe Ray Garcia was the one I dealt with for the plea.
That's who.
Yes, Judge.
Click on some.
And there were two.
All right, the court is calling 2020 CR 4832, State of Texas versus Victor M. Rodriguez Vasquez. Can I have parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
Ed Piker.
And Mr. Rodriguez Vasquez, could you unmute for me, please?
Okay.
Are you Victor Rodriguez Vasquez?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, ma'am.
Mr. Rodriguez, I'm going to show you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am, I did.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Mr. Rodriguez Vasquez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
I do waive it.
State, are you proceeding on the indictment as presented?
No, Your Honor. We're proceeding on the lesser included assault bodily injury family, Class A misdemeanor. We also, yes.
Just 1 second. Okay, so you're proceeding on assault
Yes, Your Honor.
family Class A.
Yes, and we asked to make an oral motion to amend the indictment to include the manner and means.
All right, is there an objection to that from
No
the?
objection.
All right, what is your oral motion?
Yes, Judge, on the indictment, paragraph B, we move to insert the manner and means, which is after the part without the effective consent of Cassandra Esparza Lopez by striking Cassandra Esparza Lopez with a statue.
Any objections?
No objection.
Mr. Rodriguez Vasquez, do you understand that the state has made an oral motion to amend the indictment?
Yes, ma'am.
Do you understand that that oral amendment is a substantive amendment and that your attorney will have time, if he so chooses, 10 days before proceeding? Do you understand?
Yes, ma'am.
Do you still wish to proceed?
No.
Do you wish to go forward with this plea or no?
No, ma'am.
All right.
Victor, this is the court and the prosecutor reducing the burglary of a habitation to an assault Class A misdemeanor. The judge wants to know if you agree with that or not.
Oh, yeah. I'm sorry. I wasn't understanding right everything.
Okay, you need to put on the listening ears. All right.
Okay.
So my question to you is, You've heard that the state has changed a paragraph in the indictment. Did you hear that?
Yes,
All right, you understand that because that change is substantive, number one, your attorney will have 10 days to prepare before proceeding. Do you wish to go ahead with whatever agreements you have entered into? Or do you wish for a reset for your attorney to prepare?
I wish to proceed.
So you have no objection then to the state's amendment to the indictment. Is that correct?
Yes, ma'am.
Defense, you have no objections to proceeding?
No objection.
Then Mr. Victor M. Rodriguez Vasquez, I'm showing you a document entitled Court's Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand what you're charged with in paragraph 1 of the indictment is burglary of a habitation with intent to commit assault? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years with a possible fine up to $10,000. However, the state is proceeding on the lesser included offense of assault bodily injury family as a Class A misdemeanor. The range of punishment for that offense is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Victor Rodriguez Vasquez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No, ma'am.
All right, Mr. Vasquez, are you able to speak English and understand English?
Yes, ma'am, I can read, right?
Okay. And so all of the documents that I have are written in English. Were you able to go over those with your attorney in English?
Yes, we did.
And is English your first language or second language?
It would be my second language.
Okay. And do you feel comfortable going forward in the English language?
Yes, ma'am, definitely.
Counsel, did you advise your client of the consequences of pleading no contest or guilty in the application of federal immigration law?
Yes, ma'am, I did. And for purposes of the record, I did tell Victor that I would state on the record that I have advised him against entering into this plea based on the facts of the case and his potential immigration problems with deportation, reentry, ineligibility to stay, and that he does have an ICE hold already. But under current state of the laws, Victor has instructed me that he wishes to proceed and enter this plea. So against recommendation, he is entering this plea. And I would just like Victor to say if that I stated that correctly or not.
Yes.
All right. And counsel, do you believe he understands the immigration consequences of entering a plea in this cause?
Yes, I do.
Mr. Rodriguez Vasquez, did your attorney advise you of the consequences of pleading no contest or guilty in the application of federal immigration law?
Yes, ma'am, he did.
Did that advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
Yes, ma'am.
And did you understand, or do you understand the immigration consequences of entering a plea?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am, we did.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault, bodily injury, family as a Class A misdemeanor. Punishment is to be assessed at 346 days in the Bexar County Jail. There's a $1,000 fine. This will run concurrent with 640866, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am, I did.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that an affirmative finding of family violence will negatively impact your immigration status?
Yes, ma'am.
Did you understand that to be the entirety of the plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
Yes, Judge, with the running concurrent with 640866, it's my understanding that the district attorney is going to advise the district attorney in County Court 4 that the case there is to be reduced to a DWI first.
Is that correct, State?
Yes.
Okay. And then, Mr. Garcia, is that the entirety of the plea bargain agreement as well?
Yes, Your Honor.
Judge, I am
Next,
asking that the fine run, time and money run concurrent.
Okay. Next, I'm showing you what's entitled Waiver Repeal. Did you review that paragraph with your attorney? Did you understand it, and did you electronically sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
All right, then to the council, have there been any such motions?
There have not.
Then Mr. Rodriguez Vasquez, to the offense of assault, bodily injury, family as a Class A misdemeanor. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
State offers State Exhibit 1 and all its attachments.
Any objections?
We have reviewed them. No objection.
Mr. Rodriguez Vasquez, I'm showing you what's entitled Waiver and Consent, the stipulation of testimony and stipulations. Did you have a chance to review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, ma'am, we did, and I did sign.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call and right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed the same. The court is finding there's sufficient evidence to find you guilty, and the court will find you guilty of assault, bodily injury, family as a Class A misdemeanor. Are we proceeding with sentencing?
Yes, ma'am.
Court will follow your agreement, sentence you to 346 days in the Bexar County Jail. Credit for time served, $1,000 fine, time and money to run concurrent. There's an affirmative finding of family violence, and this will run concurrent with cause number 640866. The court will note on the docketing sheet that that case number is to be reduced to DWI first. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Not from defense.
All right, next I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, Mr. Rodriguez, good luck to you. Do better. Know better, do better.
Okay.
You understand?
Yes, ma'am, I will. Thank you.
All right. Is there anything else, Mr. Piker?
No, ma'am.
All right, thank you for your patience, Mr. Piker. Norma, can you let them know that 17K can go back?
Yes, ma'am.
All right, who are the parties on
Thank you, everyone.
Ray? Thank you. Who are the parties on Ray Gomez Beltran?
Hunter for the state, Judge.
Cecil Bain for Mr. Beltran.
All right, Brenna, do you need a break?
Yeah, can I run to the restroom real fast?
Yes, sure.
Good afternoon, Judge.
Good afternoon.
I just wanted to update you on my client, Mr. Salazar. I understand that he is not.
Just one moment.
Sure, absolutely.
Yes. Mr. Ambrosiano?
Yeah, yes, sure.
Yes.
Amber, oh gosh, you butchered it. Come on, I know you know how to say it, right?
I know. We've been zooming
Sure.
since, I've been here since 7, so we've been zooming along.
Yikes.
I should have just said, where are my Pittsburgh Steelers?
And it just would have been me. It would have been easy.
Yeah. I guess I can't say that because we're in Texas.
I see more bumper stickers than you would think, surprisingly.
I don't know. I still remember Roger Staubach, and I remember, my brother would dress from head to toe in Cowboys outfits. And, it was painful a couple of times with the Steelers. But.
Yeah, they beat him a few times. They got back at him in the 90s.
Yeah.
But so
Ambrosino.
there you go. You got it.
All right. So what is happening with your client?
We had an agreement worked out. I've been in contact with him like all week, and
Yes.
he was seeming to get some cold feet, and it seems that he has not appeared. He would not return my calls earlier today. So
All right. So who is the prosecutors on your case?
That's me, Your Honor. Richard Guetta. I'm here in the courtroom. Can you hear me?
Yes, I can hear you.
I'm right here.
All right,
Oh, can I come up?
courtroom, could you have him show his video and everything? All right, thank you. So to the state on Mr. Ambrosino case. And Mr. Ambrosino, what is your client's name?
Felipe Salazar.
Is it Felipe Miguel Salazar?
I have the cause number, Judge. I'm not sure of his middle name. It's
What is the clause number?
2020 CR 2520 and 2521. He has 2 MTRs.
All right. Mr. Bain, this will take us just a small amount of time, and then we're going to take up your case. Court is calling 2020 CR 2520 and 2020 CR 2521, State of Texas versus Felipe Miguel Salazar. Can I have parties announced for the record for the state?
Richard Guetta for the state.
For the defense?
Roberto Ambrosino for Mr. Salazar.
All right, this hearing was scheduled at 2 p.m. It is now 2:58 p.m. Deputy Laura, is there Felipe Miguel Salazar in the courtroom?
No, Your Honor, he is not.
And has he been in the courtroom at all today?
No, Judge, he has not.
All right, and for the record, there is not a Felipe Miguel Salazar on the Zoom screen. Defense, have you had any contact with your client?
Yes, Your Honor. I've actually had extensive contact with him up until late yesterday. I actually even tried to call him today, but I did not receive a call back today.
All right. All right, state.
Your Honor, I request the court please forfeit Mr. Salazar's bond. Though we were negotiating a plea deal and had something worked out, I did bring in all of my witnesses for this hearing. And so they've been waiting here for the past hour.
All right, so I'll grant the bond forfeiture and remand him without bond. Mr. Ambrosino, if you're able to get in touch with your client and present him to the court, then the court will reconsider. But for now, your client is remanded without bond on each case, and the court is granting the request for a bond forfeiture.
Okay, thank you, Your Honor. Maybe.
All right, yes, thank
Your
you.
Honor.
Thank you. Yes, that's all. Thank you. Have a good one.
Thank you.
Mr. Barnes, I need you to turn your video back on. Hi, Mr. Barnes, could you unmute for me, please?
Can you hear me, ma'am?
Yes, I can hear you. Okay,
Yes, ma'am.
Mr. Barnes, this is what, first of all, thank you for your patience. I greatly appreciate it, okay? All right, Mr. Barnes, this is what's happening. So we were actually bringing you back because I wanted to make sure there was an update on your evaluation that was completed. So my understanding is that the evaluation has been completed. So they're going to give you some help and then we'll be able to take care of your case, okay?
Ma'am, I would like to dispute that evaluation. It's false. It's a falsehood, ma'am. It's ridiculous.
So this is what I'm going to do then, Mr. Barnes. I'm going to have you set in the magistrate's court and you can actually have a hearing on your dispute of the evaluation. And if you want another evaluation, the court will order another evaluation for another doctor to review it.
So was it court order for me to have an evaluation initially? Is that why that had to occur?
It was requested. So that's why you
I
had
did
it.
not. I didn't request an evaluation. They told me that I had to take one under duress. They said that I would not be able to see a judge or speak to a lawyer without one.
Well, you're speaking to me. Okay. So this
Yes,
is
ma'am.
what we're going to do, Mr. Barnes. I'm going to reset you for 2 weeks and
Okay.
I'm going to get in touch with the magistrate's court so that they can have a hearing about your evaluation. And if you would like another doctor to give another evaluation because you're in disagreement, I can arrange for that to happen. Okay.
So do I have to go through another evaluation because there was one
No,
requested previously?
You don't have to go through another evaluation if you don't want to go through another evaluation. That's something that we'll get you to discuss at another date. But I'm going to reset you for 2 weeks and we'll have the magistrate take care of it. Okay.
Okay. Well, I was hoping. I guess is that the process in which this would have to go. I'm not familiar with this evaluation scenario.
Yeah,
I've been
that's
in
the
court before, and typically I just speak to a lawyer, I speak to a judge, and I'm out. You know.
No, that's the process that they do now.
Oh, I
And
see.
we actually have a magistrate who handles all of the evaluations that happen. So we have a magistrate who does that. So I want to make sure that we let the magistrate do it. Okay.
Yes, ma'am. Of course.
All right. Do you have any questions about anything else?
I guess as far as this situation goes, I've been in for 2 months on a misdemeanor charge trying to request a PR bond. Is there any way that I could request that PR bond? I had school that I was supposed to start at the beginning of this month. I paid $14,000 to start into a program for IT security and networking. I have not been able to, complete that course or go to the course, I guess,
Well,
meetings at all.
Mr. Barnes, this is a felony court, so I only handle the felony issues. So if you have a misdemeanor charge that's pending, then that misdemeanor court will be the person in charge of that, okay?
Okay, so I'd like to ask, what is my charge for this? Because they're telling me
It's criminal mischief.
Okay, and so they told me when I initially got here, I'd be released on a PR bond and it was a misdemeanor. So you're telling me that I'm in felony court, so what
This
are
is
my
a felony
charges?
court.
Oh, it's not.
Yeah, this is the 187 district court. It's a felony court.
Okay, so what am I
misdemeanor-
charged with? I don't even know what I'm charged with at this point.
Okay, you're
Yeah.
charged with criminal mischief. So here's the
Okay.
thing.
What were the
Misdemeanor-
Yes, ma'am.
I'm out. Misdemeanor courts in Bexar County are called county courts at law. So whenever you see someone in a county court at law, that means they have a misdemeanor charge. So what I'm going to do, Mr. Barnes, we're going to recall you back in 2 weeks so I can make sure that all of your questions are answered, okay?
Okay, can I receive a formal indictment as well sent to me? Because I haven't, literally,
I
ma'am,
will
I
make
have not been
sure,
told
here's the
anything.
thing, I will make sure that you get everything that you're requesting, okay?
Thank you, thank you.
You're welcome, Mr. Barnes. Norma, can you recall Mr. Barnes for 2 weeks, please? All right, so you're going to come back on June 7th.
June 7th.
Yes, and I've notated it on my docket sheet, so we'll make sure that we get you here, okay?
Okay.
All right, thank you, Mr. Boynes. Mr. Boynes, just remain there. They're gonna take you back. Norma, can you let them know that 17A can go back? Thank you for your patience, Mr. Boynes.
Thank you for your information, ma'am.
You're welcome. All right, Mr. Bain, we're gonna call 2020 CR 2204, State of Texas versus Ray Gomez Beltran. Can I have parties announced for the record, please, for the state?
Under Morris for the state.
For the defense?
Cecil Bain for Mr. Beltran.
All right, are you Mr. Beltran?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state or the defense?
None from the state.
No, Your Honor.
Mr. Beltran, I'm showing you a document entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor, I did.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I believe I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Beltran, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor, I did.
Counsel, do you waive the reading of the indictment?
We waived the reading.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Beltran, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, Your Honor, I did and I signed.
Did you understand what your charge was? Evading arrest, detention with a vehicle? That's third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I did, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, I do, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, Your Honor, I understand.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Beltran, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
I'm super satisfied.
Are you a U.S. citizen?
Yes, yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Cecil, Brenda
Yeah,
took
sure.
down the record for that. So if you want her, if you want that printed out.
Yes, I would, and I'd like it autographed by all the staff that helped me be a good lawyer in this case.
Okay. Mr. Beltran, I'm showing you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, I did, Your Honor. Now,
According to the plea bargain agreement, the state is requesting a $1,000 fine, recommending deferred adjudication, taking in consideration 563350, and there's restitution, if any, to Jorge Mendoza. Did you understand that plea bargain agreement?
yes, ma'am.
Defense, is that the plea bargain agreement?
Yes.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled Waiver Repeal. Did you review that paragraph with your attorney? Did you understand it and did you electronically sign it in both places?
Yes, Your Honor, I read it and I understand it.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 120 hours of community service restitution, no contact with Jordan Maas, MAAS, anger management course, defense and driving course, MRT or CBT. What is MRT and CBT?
The more recognizance therapy, Judge.
And CBT?
Cognitive behavioral therapy. I believe the MRT is offered at the SATA facility here locally, but probation should be familiar with it.
All right, thank you. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor, I understand.
All right, then to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
State offers states one with attachments, Judge.
Any objections?
We reviewed state one with our client. We have no objections.
Mr. Beltran, I'm showing you a document entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor, I read it and I understand it.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, ma'am.
Did you understand today that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
All right, is there anything
Yes,
you
Your
wish to
Honor.
say on behalf of your client?
Yes, the facts of this case are that he was having a bad day and had an automobile accident, and got scared and was evading. So that's what happened. And then he evaded at the time of this arrest. They're connected, and part of the plea bargain is that correct? TIC, the assault case, I believe.
Yes.
He is supported by his sister whose car he was driving. There was insurance, and when he gets out, he wants to work on his GED, and so he doesn't get in this situation again, Your Honor.
Okay. Mr. Beltran, how old are you?
22.
All right, who is this Thalia Thurston that was in the car?
Oh, Talia, my brother's girl.
Yes. Okay. Do you know so many things could have went wrong with this, right? Like a lot of people could have died, people could have been seriously injured. So what's going on in your life? Why are you doing these things? Tell me about yourself. What should I know?
I don't do those things. I'm actually live with my brother. He's a real estate and I love working with him, doing open houses. I'm the manager's marketing assistant. So I've never been in trouble with the law. I got scared because honestly, I see every day in the news how cops shoot first and.
Okay, let me ask you this. So why does the state think that maybe you need some sort of cognitive therapy or some kind of moral therapy behavior? Do you know how to make right decisions in your life?
Yes, I do. It was just that I was scared that day.
All right, here's the thing. I need to give you conditions where you'll be successful. I don't want to put you out in the world where you fail at probation. So is there something that you need from the court to be successful if I grant this deferred adjudication?
No, honestly, to be successful, I always like follow my big brothers. He has his own company, advices, and he always talks to me. So, yeah.
All right, Cecil, do you think he needs anything other than what's listed here?
I don't believe so, Your Honor. As per my discussion with Hunter, if you consider probating some of the fine and assisting him maybe on community service if he does his GED, which he wants to do, those would be beneficial to him, I believe.
I'm trying to do my GED so I can go to Job Corps. I want to do a K-9 school.
Okay. All right, this is what the court is going to do. 3 years deferred adjudication, $1,000 fine, that'll be probated. Take in consideration 563350. Restitution, if any, to Jorge Mendoza, 120 hours community service restitution. That will be waived if you complete your GED or in some type of trade school. No contact with Jordan Maas, MAAS, anger management course, defensive driving course, proof of employment within 30 days, no employment with vulnerable persons. So that means that you can't be a home health care provider and you cannot do anything that involves you supervising minors. You understand?
I understand, Your Honor.
Are you able to report by Zoom?
Yes, I'm able to report by Zoom, Your Honor.
All right, regular Zoom reporting or in person. If something happens and you can't report in person, then, by Zoom, you need to report in person.
Yes, I can.
Random UAs or the patch. The patch costs more, but it's not as, it doesn't take as much of your time up as going down to get a random UA. If you have the patch, you have it on, but the patch is more expensive. Rebecca, is there anything else that he needs to be successful?
No, ma'am. Are we not going to do the moral and the cognitive?
Yes, I don't, from what I'm reading, it appears that you have a young kid in an accident, doesn't react correctly as far as pulling over. So, if probation finds out that his wires are not working or he's not proceeding the way anyone else would proceed when decision making, then let me know and I'll change that. But
okay,
from speaking to him, it doesn't seem as though he needs that.
Okay, I just wanted to verify.
Sure. But you know what? Let's do a random field visit one time per month. All right, Mr. Beltran, do you need anything else from the court to be successful?
No, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor, I did and I signed it.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, Mr. Beltran, I'm going to send you to a breakout room. Probation will go over conditions with you. Mr. Bain, you can go over, be in the same room with him if you choose, or you can be excused. And
I would like to remind him, we've had extensive discussions to follow what the probation officer recommends because they're trying to help him in his best interest. So he should call me when he gets done and gets out.
All right, thank you, Mr. Bain.
Thank you, Mr. Bain.
All right, if you will go to breakout room number 4.
All right, thank you so much, Your Honor. Bye.
Thank you. All right.
Thank you, Your Honor, for indulging us. Thank you, Hunter.
No, thank you, Mr. Bain.
Yes, sir.
All right, anyone else is ready? Hunter, you had
Your
a
Honor.
question? Hunter?
Yes, Judge. I submitted the dismissal to you for that case taken into consideration, and I'm posting in chat the correct terms for those programs, just for everyone to know. I mispronounced it.
All right, no, I appreciate it. You know, it's always vegetable soup.
Your Honor, we have the hearing that requires the interpreter.
Okay. Just give me 1 second. I'm going to take that up. And then after that, I'm going to take up Mr. Hendrickson, who's been very patient. All right, so
Judge, I'm sorry to interrupt you. I don't believe my client has still been brought.
All right, this is what I'm going to do. Norma Ferguson, if you could go to breakout room number 6, please.
Yes, ma'am.
And Mr. DeWiggins, if you go to 6 and let Ms. Ferguson know who your client is, we'll take that up.
Thank you.
Was that a picture of Roy Rogers in the background?
Could be, somebody could be bringing Roy Rogers. I don't know.
Saw a picture in the background. Look at Roy Rogers.
Okay, Cornelius, I know you had your Roy Rogers boots and everything. All right, who's the prosecutor on Mr. Riojos?
Oscar Salinas.
Thank you.
Judge Hunter Morris will step in.
All right, thank you.
Oscar was called away.
Okay, thank you.
And I'm still waiting for family violence in the breakout room. They never showed up.
Okay, could someone from Family Violence please go to a breakout room and speak with Mr. Cox? Mr. Cox, if you'll go to breakout room number 2, and Joe Ray or either David Martin will meet you there.
Thank you, Judge.
You're welcome.
Okay.
All right. All right, the court is calling NITMAG number 959. Sorry, this is with the interpreter, correct?
Right.
Who's the interpreter?
I saw the interpreter here earlier.
All right, I'm trying to see the interpreter and I don't. All right, we're bringing the interpreter back, Mr. Rodriguez. Just give us a moment. All right, Raymond Martinez, who are you here for?
Judge, I have 2 people. I have from this morning, Anthony Martinez was a modification of bond conditions. He wanted the complainant to come in. I think she's been logged on since 2 o'clock. Her name is Amanda Medina.
Okay, just 1 second. And who else?
The other one is Juan Montes from this morning also was a motion to revoke. We did confer. I do have an offer. We're not necessarily rejecting it, but my client's asking me to approach the court about a bond because we're not prepared to take the offer today for reasons I can explain.
All right, what reasons do you want to explain to the court?
Mr. Montes the state is suggesting, or probation is recommending that he go to ISF. He's not necessarily rejecting that proposition, but he has dogs in a house that have been unattended to for about a week. And he wants to fix all that before he's sent off to the waiting list to go to ISF.
How long has he been in custody?
Only a few days, Judge, and he says the dogs have been unattended to without food or water, and he's very worried about that. He lives alone.
So you're telling me that there's nobody he can pick the phone up and call? You're muted.
He can call his wife, Judge. They're separated. They don't live together, but she's afraid of the dogs. She doesn't want to go near him.
Because I don't even know who would be making his bond if he doesn't have anybody, unless he took money with him on his books.
Judge, I have total control over that aspect of the case.
All right. All right. Just give us a moment. I'm going to take this up with Ms. Nero.
Thank you, Judge.
You're welcome. for some reason, Ms. Nero, it's not letting me add you. So let me see if we can. Just one.
Oh,
second.
I got it, Judge.
Okay, all right, awesome.
Who is the defendant, Judge, so I can
It's
instruct him?
Eduardo Rojas Mejia. All right, he is here on the screen. If he could unmute.
Okay, Judge, may I just one moment, please?
Okay, thank you.
Thank you.
Mr. Mejia, are you doing okay today?
Yes.
Okay.
Ok, señor Mejía, ¿me escucha?
Sí.
Ok, ¿está usando celular o está usando computadora?
Computadora.
Ok, entonces ve en la parte de abajo, le va a aparecer un pequeño mundo. Presione ahí con su cursor y seleccione español.
Mundo español.
Es un pequeño como pequeño mundo.
O interprete, donde dice interpretation.
Exactamente. Y presiónele
Español.
ahí y luego seleccione español. Ok. Judge, I'm going to switch to Spanish. I'm going to activate and everybody else selects English.
Sí, ya le puse español.
Okay. For some reason, it wouldn't let me select start. So I don't even know if it's on.
I can't hear the interpreter. Oh, now I can.
Okay, great.
Okay.
All right, the court is calling NITMAC number 95992, State of Texas versus Eduardo Rojas Mejia. Could I have parties announced for the record, please? For the state,
Hunter Morris for the state.
for the defense?
Daniel Rodriguez. And Your Honor, this case is now
Mr.
been-
Rodriguez, you need to switch to English.
Okay, I've done that now.
Thank you.
This case is now indicted, and the indicted cause number is 2021 CR 3351.
All right, and for the defense?
Daniel Rodriguez.
And we have an interpreter here. Ms. Nero, if you could raise your right hand for me, please. Do you solemnly swear or affirm you will faithfully translate from Spanish into English and from English into Spanish to help you God? And could you state your full name for the record, please? All right, Mr. Mejia, your attorney has filed a motion to withdraw as attorney of record. Did you have a chance to speak with your attorney about his motion to withdraw?
Sí.
Mr. Rodriguez, this is your motion.
Your Honor, the reason I filed this motion, unfortunately, is because we haven't been able to fulfill the terms of the contractual obligation. We took on one of his three cases to start off with to, I guess, help out with the financial needs of the person who hired us or who reached out to us. So we charged a reduced rate for taking on one of these cases. And unfortunately, we haven't received any payment at all on the case. The other two cases, the defendant is represented by Ricardo Ramos. And I've spoke with the state about this, specifically Oscar, and Oscar does not object to my motion to withdraw. And he also informs me that the three cases are pretty much identical and that the discovery I have on one case is the same discovery that Ricardo already has as well. So the defendant wouldn't be, I guess, any worse off with having one attorney handle all three cases because it's the same discovery across the board.
All right, State, do you have any objections to the defense's motion to withdraw?
No, Judge, I spoke with Oscar and that is correct. We do not object to the withdrawal, and the appointed attorney on the other case should have all of the same evidence he's allowed to have under law for these cases.
All right, Mr. Rojas, do you have any objection to Mr. Rodriguez withdrawing from your case?
No.
All right, then I'll grant your motion to withdraw. Mr. Rojas, to make sure that everyone is on the same page, I'm going to recall your case in 2 weeks to have your court-appointed attorney here. Are you going to proceed on all cases with the court-appointed attorney?
Sí.
All right, thank you. With that, we'll close the hearing. Norma, can you give me a 2-week reset for Mr. Rojas, please?
And may I be excused, Your Honor? I have
Ya
another.
tengo un abogado
Yes.
de la corte. ¿Lo van a cambiar o va a tener el mismo?
No, it will be the same attorney.
June 7th.
Gracias.
All right, and Mr. Rojas, you'll be coming back
Okay.
on June 7th at 9 a.m. and we'll have the attorney here for you.
Gracias.
All right, thank you. And Norma, can you let them know that L2 can go back? Ms. Nero, thank you. And tell Ms. Abrams, thank you.
Gracias.
Thank
All right,
you.
bye-bye.
Thank you, Your Honor. May I be excused?
Yes,
Thank you.
yes. All right, Sean Hendrickson.
Good afternoon, Your Honor.
Yes, just 1 second. Who's the attorney on your case? It's Mr. Ward, is that correct?
Client is Mr. Ward, Michael Ward, that's right.
All right, who's the prosecutor on Mr. Ward's case?
Marcus Sanders. And this morning, I believe that Angela Blake was appointed to represent Michelle Ward.
And I'm here, Judge.
Thank you. All right, the court is going to call NIMAC number 612332, State of Texas versus Michael Ward. Could I have parties announced for the record, please, for the state,
Marcus Sanders.
for the defense?
John Hendrickson.
And if a witness is called, that will be Michelle Ward. And could the attorney who's representing Ms. Ward as a witness announce for the record, please?
Angela Blake, attorney for Michelle Ward, we're present and ready.
All right, and are you Mr. Ward? Could you unmute for me, please?
Yes, Your Honor.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No objections, Your Honor.
Ms. Blake, if Ms. Ward is called as a witness, will there be any objections to appearing by video?
No, Your Honor.
All right, we're here with a motion to modify the no contact order. Defense is asking that the defendant and the complainant, Michelle Ward, in your motion, you mentioned the complaining witness, Amy Ward.
Your Honor, Michelle Ward, Ms. Ward goes by both Michelle Ward and Amy Ward. It's the same person.
All right, so
And I'll address that.
No problem. So in the motion to modify, the defendant is requesting that Amy/Michelle Ward be allowed to have contact with Michael Ward. Defense, have you had a chance to review the motion? And are you ready to proceed?
Defense or state, Your Honor?
I'm sorry, state, are you ready to proceed?
Yes, Judge.
All right. Defense, is your motion. You may begin.
I'd like to call Michelle Ward.
All right. Ms. Ward, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Could you state your name for the record?
Amy Michelle Ward.
All right, defense.
And Ms. Ward, you go by Amy Ward as well sometimes. Is that correct?
Yes,
Okay. And how do you know Michael Ward?
he is my oldest son.
And are you aware that Michael was arrested recently?
Yes,
And are you aware that that because of that there was a no contact order?
yes.
Okay. And do you know who the no contact order applied to?
It applied to myself.
Okay. And when Michael was arrested, did you want there to be a no contact order?
No, it was a very much a surprise.
Okay. And at any time before, during, after the arrest, do you feel like Michael posed a danger to you?
No,
And so you do not believe, or I guess, do you believe that a no contact order is necessary?
no, I do not.
Okay. And would you like the court to change that no contact order so that Michael could have contact with you?
Yes,
Okay. And where was Michael living, I guess, before he was arrested?
he was living here in my home.
And would you like for him to be able to come back home?
Yes, very much.
If he were to move back in with you, would you be afraid at all of Michael?
No,
Okay. At the time that Michael was arrested, he had been drinking, hadn't he?
yes,
Okay. Do you know if he has been drinking since then?
no. To my knowledge, he's been sober for 20 days.
Okay.
He's been going to AA meetings.
And do you think that he would have, would you be there to support him through trying to become sober and to maintain his sobriety?
Absolutely. Yes.
I think that's all the questions that I have for Ms. Ward.
All right, state.
Thank you, Judge. Mrs. Ward, were you afraid of Michael on the date that he was arrested?
No,
Okay. Who was it that called the police?
it was my son, Jacob.
Okay. Are you aware why your son called the police?
The day that Michael was arrested, he was drinking heavily and he was yelling, and most of the anger was towards Jacob. And so when the police came out, they asked Jacob to leave for a little while. So he did. So it was just me and Michael in the house.
Okay, and tell the court what happened next.
So after Jacob left, Michael was sitting in the floor at the top of the stairs with his handgun. And I was at the bottom of the stairs. Well, first I was at the top of the stairs telling him to just put the gun away and go to bed. That's all you need to do. Just nobody's going to come take you anywhere if you just go to bed. Put the gun away and go to bed. So I went to the bottom of the stairs to clean up some glass that got knocking off the railing. And that's when he started firing shots.
Okay, and I believe in your statement, you said that you felt that your ears were ringing, the shots were so loud.
Yes.
How many shots did he fire?
I only counted 4 or 5.
Okay, and you ran out of the house once he started shooting, correct?
Yes.
And prior to, I guess, your son, what's your other son's name?
Jacob.
Jacob. Prior to him leaving with the deputies, isn't it true that Michael made statements that if the police tried to take him out of the house, he would shoot them?
Yes.
How many guns does Michael own?
Just the one. And it was taken by the police the night that he was arrested.
Are there any other guns in the house?
Not at this time.
I pass the witness, Judge.
All right, defense.
Yes, Your Honor. Ms. Ward, you said that that Michael had fired shots in the house, correct?
Yes.
Where were those shots aimed at, if anything?
They were aimed at a wall.
Were they aimed higher up on the wall or lower on the wall, or kind of where?
He was sitting on the floor and they were aimed upward to the wall next to him.
And was he on the bottom floor or the top floor?
He was on the top floor.
And so the shots weren't aimed at anybody in particular, is that right?
That's correct.
Did he aim the weapon at you or threaten you with the weapon?
No, he did not.
And you said that there are no guns in the house right now, correct?
That's correct.
Are there any plans to bring guns back into the house if Michael were to come back home?
No.
Do you think that your husband lives at the house also, right?
Yes.
Do you believe that being in your house or being in the house with you and your husband would be helpful for Michael?
Yes, I do. We are his only support system.
If the judge denied this motion and kept Michael from coming home, where would Michael go to live?
I don't know.
Okay. Do you think that it would be, I'll withdraw that question. No further questions, Your Honor.
All right, State, any other questions?
Yes, Judge. Does Jacob live in the same home with you and Michael and your husband?
Yes.
And on the night of the offense, Michael was threatening Jacob, correct?
He was not threatening Jacob. He was just yelling at him and yelling in his face.
Okay, so if you said in your statement, do you remember writing a statement?
I remember writing a statement.
Okay. You remember stating in your statement that Jacob, let's see, he proceeded to drink more and continued to yell and started threatening his brother.
Oh, he threatened to punch him is what. He never threatened to shoot him. He threatened to punch him.
Okay, but he did threaten to shoot the
Yes.
police officers.
He said that if anybody tries to take him out of the house, he would shoot him. Yes, he said that.
And how did he eventually become into custody? Like, how did he get arrested?
So what happened is that when there was kind of a standoff in the neighborhood for a couple of hours until a major storm broke. That night it started hailing and severe thunderstorms. So everything kind of got broken up. So with the police officer that had me in the back, that I was in his squad car, he drove me to meet my husband at a gas station. And then after that, we drove back to the house and my husband went in and found Michael. Michael was passed out. So he removed the gun from Michael's use and brought him downstairs. He continued to be belligerent and just yelling. And that's when the police took him in. The police came back and they took him in to custody.
Thank you, Mrs. Ward. No other questions, Judge.
All right, any other questions, defense?
No, Your Honor.
All right, thank you for coming in to talk with us, Ms. Ward.
Thank you.
Yes, we did. I gotta sign this case.
Everyone, if you need to make sure you're muted. All right, defense, any other witnesses?
No other witnesses, Your Honor.
All right, Mr. Ward, is there a reason why you have a black background and it appears that everything is blacked out?
I'm not familiar with anything like that.
No, whenever you go on video and it's on Zoom, it automatically shows whatever background you're at. The only way that your background is something else is if you change it yourself manually. It doesn't automatically come up with a virtual background. But this is just me just wondering. All right, State, do you have any witnesses?
No, Judge, no witnesses.
All right. Oh, thank you, Mr. Ward.
I'm
right.
sorry about that.
No problem.
I do the virtual AA meetings, and I just do that out of preference, I guess.
All right, no problem. The court will hear argument. Defense, it's your motion. You may proceed.
Yes, Your Honor. We are asking for the no contact order to be changed to a no harmful or injurious contact. Right now, the order as a condition of bond is that Michael Ward not have any contact with his mom and also not go back to the home that he was living in, which is his parents' home. We're asking for that to be changed again, so that he can have contact with his mom again, and so that he can return home. Ms. Ward has stated that she does not have it, that she has never wanted the no contact order. Despite everything that happened, she is not afraid of, she doesn't feel like Michael has threatened her or put, is a danger to her. And further, Your Honor, since my client's arrest, he has remained sober, and we feel that it would be helpful for him to have his parents as a support system if he were not able to go back home. Then I feel like he would be in a worse position as far as continuing with his sobriety.
All right, State.
Yes, Judge. When I was speaking to Mr. Henriksen, I told him that I didn't have a strong objection to it, but it was something that I couldn't agree with, and I wanted to make sure that, I guess before you made a decision, that you had the facts of the case before you. It's concerning, the facts that he threatened his family members, that he's still living in the same house, that he had a gun and that he fired it. I understand. So he doesn't really have any criminal history. And I see that his mother is wanting him to live there. So I believe that whatever the court decides to do will be appropriate.
So here's the court's question. So Jacob lives there? Is that correct?
That's what the mom testified to. Yes, Judge.
So basically we have a mom who's gonna have to choose which son, correct? I mean, because it's obvious to me that I'm assuming that Jacob does not want him at the home, and the threats appear to have been to Jacob.
Your Honor, that's not my understanding, Your Honor. They were just, it was a fight between brothers. I don't know. There was not a no contact order between Michael and his brother. It's not my understanding that she would have to make a decision, or that Jacob would leave, or anything else if Michael were allowed to come back home. Further, as of right, my client is working in Louisiana in the oil fields. He has a position where he is there. He's working for a couple weeks, and he's off for a couple weeks, and so he wouldn't be home continuously, but he would have the ability to come home on the weeks that he is off, and would be able to be around his family at that time.
This is the court's concern. I find it concerning. I understand that drugs can make people do things maybe they normally wouldn't do, but I have a problem with somebody. It appears that the reason for this is, I guess people think alcohol played a role, but usually it's not alcohol. Let me grab a gun, I'm in an argument, then let me fire the gun. I find that very concerning. And it's very concerning that the witness testified that 4 or 5 shots were fired, and she made it seem as though it was just 4 or 5 shots. I find that very concerning. So I know the mom wants him there. I know sometimes that complainants are forgiving and they want the person there. So what assurances do I have that we're not going to be back here again for this? I know the mom is saying, well, there were guns in the house, but they've been removed. But how do I know that this is not going to happen again? Because it appears that whatever issues caused this, and Mr. Ward, I want you to know, if this ends up going to jury trial, of course, I will listen to whatever facts that are given to me and look at it with a clear mind. But it appears to the court that whatever happened, even though people want to say that alcohol was a contributing factor, whatever caused a gun to be drawn and fired, whatever's going on with the relationships in that house have not been resolved. Because what we've had happen is you have an incident that happens, shooting in a house, Jacob leaving the house for Mr. Ward to calm down. He did not. He fired shots. And then we have the no contact order. He's out of the house. He's done some AA meetings. And then That's it.
Your Honor, if I may, I'm sorry, but that's not it.
Excuse me.
I mean,
just 1 second. So, I mean, that's where we are.
I mean, the
So
night
does
that this
any,
happened,
excuse me, you're no longer on the witness stand. So my question is, what can be given to me as an assurance that this is not going to happen again? State, do you have any concerns that this could happen again with this defendant moving back in that house, getting into whatever argument he's in with Jacob? I don't know what that argument was about, but obviously it was a pretty serious argument that two brothers couldn't handle over fly fishing. So.
Yes, Judge, I share the same concerns that you mentioned. And that was my thought too, was that even if alcohol was involved, for it to escalate to that point was the concerning part.
Your Honor, if I may,
Yes.
there's no way for us to guarantee that something's not going to happen again. Obviously, we would be fine with condition of probation if it's not there. I don't think it is in this case, but being that my client can't own or possess firearms, but there's no way that we can give the court 100% assurance that something's not going to happen in the future. What we can look at is the fact that my client doesn't have any criminal history or anything. He had an arrest when he was in high school, but that case was ultimately dismissed and was not any sort of violent offense. And we can look at what my client is doing now to address any issues. I understand that the court, thinks that this isn't solely an alcohol-related issue, but you mentioned that it seems like not all of the issues have been resolved, and for those issues to be resolved, Your Honor, I think that they have to be able to have contact. And so, as maybe some middle ground, maybe we could have the no contact order changed for a short period of time and check in with in a month or so to see how things are going and address whether or not any changes are necessary at that point.
So you're saying keep the no contact order and come back in a month?
Well, I was actually asking for the motion to be granted temporarily. So come back. So let them have no harmful or injurious contact for the next month, and then check in to see if things are going well. That now that they've had contact and that they've been able to talk the issues out and everything, or see if I guess just check in and see how things are at that point.
Well, I tell you what I'll do. This is what I'm going to do.
Okay.
He can have contact with the mom, but he's not allowed to go to the 402 Blue Grass Creek location. And then we can come back in 30 days and see how that's going. Because there is something else that's going on in this family that I don't know about because no one solved it. I think it's rare that you have brothers who are arguing about something, whether there's alcohol involved or not, then it turns into a deadly conduct with your client firing guns in the house, and the only people in the home is his mom and his brother who's already left. And then he's saying nobody better come in here, otherwise something else is going to happen. So maybe this will give them a chance to do whatever kind of therapy they want to do. And then you can come back in 30 days after I see how that's going, and I'll reconsider about letting him have contact with 402 Bluegrass Creek. So I will alter him then for him to have contact with Amy/Michelle Ward, but he's not to have contact at the residence. And you can come back in a month and we can come back and I'll reconsider.
Thank you, Your Honor.
All right, if there's nothing else, I'll alter the main conditions to no harmful or injurious contact with Michelle/Amy Ward. Is there anything else?
Nothing from the defense, Your Honor. Actually,
right.
one more, I'm sorry, one
Yes.
more thing. Should we schedule the 30 days now or should I contact the
Yes, we
court?
can schedule it now.
Okay.
Ms. Ferguson, can I have a 30-day reset on Michael Ward?
Yes, ma'am. And you said it was just going to be for,
Oh, just for me to reconsider my order. We'll see how things are going with their relationship and then we'll come back.
Judge, because of my client's work situation, can I check with him to see what days he's off so that he can, so we can make sure that
Sure.
I guess that works out for
I
everybody?
tell you what I'll do. I'll let you set it, Mr. Hendrickson. Just call the court. We're always available.
Okay, perfect, Your Honor. Thank you so much.
All right, thank you. We'll close the record. Brenda, sometimes court is a civil court. Yes. Yes, Ms. Blake?
Did you need me to appear at this next setting? I am available if needed.
Yes, please.
Okay, will do. Thank you.
All right, and so Mr. Hendrickson, if you'll contact Ms. Blake about the next setting, just in case you want to call Ms. Ward as a witness. And then Ms. Blake, Ms. Ferguson should get you the appointment order.
Yes, I have that.
All right, thank you.
Thank you.
Thank you, Your Honor.
All right, and then Tom, if I could see you in the breakout room with Sergio Ibarra. Where is Sergio Ibarra? Oh,
I'm here, Judge. Sorry.
all right. If you could go to breakout room number 1, please.
Yes, ma'am.
And Norma, if you could go to 1. Everyone, I appreciate your patience. Mr. Martinez, you've been very patient. Just give me a moment.
Yes, Judge.
All right, who are the parties on Suarez? The parties on Raul Suarez.
You could sit right here.
All right, awesome. Who's the prosecutor on Suarez? Who are you dealing with, Ms. Cross?
Tom was doing it, but Christian's the paperwork.
Okay, let me see if we can find a prosecutor for you.
I'm here, Judge.
Thank you. Court is calling 2020 CR 4568, State of Texas versus Raul Suarez. Can I have the parties announced for the record, please, for the state,
Marcus Sanders.
for the defense?
Stacy Kraus.
And are you Raul Suarez?
Yes, ma'am.
We're proceeding by video. The court will note for the record that defense counsel and defendant are in the courtroom, and this is one of the court's in-person days. However, the rest of us are by video. Is there any objections to us appearing by video because of the pandemic state?
No objection.
Defense?
No objections.
Ms. Suarez, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery in this case, and did you review it with your client?
I believe I have received it all, and I have gone over what we received.
Court will find that the state is in compliance with discovery. Mr. Juarez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Judge, I did.
Counsel, do you waive the reading of the indictment?
I do.
State, it appears that you are waiving the repeat offender enhancement allegation. Is that correct, defense?
Yes.
State, is that correct?
Yes, Judge, we are.
Any objections, defense, to the waiver of the repeat offender enhancement allegation?
No objections.
Mrs. Suarez, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Judge.
You understand you're charged with theft, $2,500 to $30,000. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and was.
Mr. Juarez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is asking that your punishment be assessed under 1244 of the Penal Code to 90 days in the Bexar County Jail. There are no applications. State will take in consideration 2020 CR 5268. There's restitution, if any, to Visionary Family Eye Care. Did you understand that to be the plea bargain agreement?
Yes.
Defense is that the plea bargain agreement.
Yes, Judge, we would just ask that if there is restitution, that there's a hearing on that.
All right. State, is that the plea bargain agreement?
Yes, Judge, it is.
Next, I'm showing you the
And Judge,
paragraph.
I'm sorry.
Yes.
If I may, we are going to ask that you consider Bear Gives back in lieu of the jail sanction.
Okay. All right, next I'm showing you the paragraph entitled Waiver Repeal. Did you have a chance to review that document with your attorney? I mean, that paragraph with your attorney? Did you understand it? And did you
Yes, ma'am.
electronically sign it in both places?
Yes, ma'am, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, Judge.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
Yes, the state offers states Exhibit 1 and its attachments.
Any objections?
No objections, Your Honor, to that. On the judicial confession, we are asking for the language to be changed to from judicially confess and admit to does not contest.
Any objections from the state?
No, Judge.
Mrs. Suarez, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Absolutely, Judge. Thank you.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. Can I see the state in a breakout room, please? And if I could see the defense in the breakout room.
Okay.
Courtroom, let me see where you are. If you'll go to number 11 and to the state, if you could come to 11 with us, please.
Yes, Judge. Can you move me?
Yes.
Love it. Is she not going to want him present for this? Judge, do you want my client to go back and sit down while we talk?
Okay, so here's my question.
Okay. You may not be going to custody. Let's wait and see until she pronounces the sentence.
Okay, everyone, I can hear everything. All right.
I know these lovely buttons here, Judge.
Oh,
I'm
yeah.
tempted to push it and hit mute. We have to be muted.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will follow your agreement. Sentence you under 1244 to 90 days Bexar County Jail to be served in the San Antonio SA Gives Back program. And I'll give you 2 months. Taking consideration 2020 CR 5268, restitution, if any, to Visionary Family Eye Care. And what I'm going to say is, you know what, I'm going to change that. I'm going to change that to restitution to Visionary Family Eye Care upon determination of all amounts. That way, Mr. Suarez, because my understanding from reading everything, they've obtained all of their merchandise back. But then if there's something else, then they will need to come forward and let me know. All right, next I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it? I need you to speak up.
I think they're muted.
All right, to the courtroom, could you unmute, please?
Not working now.
Thank you. All right, they're unmuted now. Yes. Because this is a plea, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I do, Judge.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am, I do.
All right, good luck to you. You're gonna remain in the courtroom, so I can send you to a breakout room so you can get all the documentation you need to be in SA Gives Back. Rebecca, do you have that information?
Well, it has to be approved, and when I heard her mention it, I emailed her. I just haven't received a response if he would be pre-approved, and I would just need to know. I know you said 2 months, but it goes by number of shifts assigned, and one shift is 8 to 12. So,
so they
2 months
don't
would be
do
8.
so 8 to 12, and let them know that they're to do 8 to 12 8 times. Is that the way it works?
okay, so 8 shifts.
Yes.
Then okay. I just wanted to make sure.
No problem. And Mr. Suarez, you should be employed. So if,
Yes, ma'am.
but
I have my own business, Judge.
okay, so you can do those days.
And I would just need to go in a breakout room and get his information so I can fill out the paperwork.
All right, courtroom, I'm going to send you to breakout room number 4. And Rebecca, if you could go to 4.
Thank you, Judge.
Thank you, Judge.
Thank you.
Maybe
Good luck to you. Do better.
After that breakout room, maybe we'd be excused, Judge.
Yes.
Thank you.
Thank you.
Okay, Ray Martinez, you have been patiently waiting.
Yes, Judge, 1 second.
Okay. I mean, Ray Martinez, your
I'm here.
pockets must be loaded down with patience. Okay, let's start with, who do you have?
Judge, I have Mr. Martinez from this morning on the modification of conditions of probation. Anthony Martinez. Sorry, guys, can I come back to you in a couple of minutes? In the courtroom? I'm gonna go
So
back.
it's modification of probation?
Pre-trial, I'm sorry.
Retrial. All right, I have Anthony Martinez. So who is the prosecutor on this? It's assault family second.
David Martin, Judge, we conferred this morning, and Ms. Medina is, I think, present on the Zoom.
All right, and the state is in disagreement, correct?
Not necessarily, Judge. I think you suggested you wanted to hear from the complainant.
Joe Ray?
Yes, Judge, from what I remember this morning, I caught the end of it was David was leaving it up to the court. Is that right, Mr. Martinez?
Basically, Judge, I think it was your call that you wanted to hear from the complainant.
All right, let's do it.
I hope she's still here.
Is it Amanda?
Yes, I think so.
Yes, she's here. So here's the thing though, Ray. Is she gonna say that this didn't happen? Or is she gonna say, is anybody gonna ask her about the facts of this case?
No, Judge, what David told you this morning was that she had related to the state that the parties were trying to go to counseling, but they had to stop because of the no contact order. So they're actually trying to amend the relationship if that's possible. But we're not gonna talk about the case.
Okay, all right, the court is calling NIMAC number 612613, State of Texas versus Anthony Michael Martinez. Excuse me, Miss Amanda Medina.
Yes,
You need
ma'am.
to find a place to park and pull over because I'm not going to be a witness to any type of accident. If you can't text and drive, surely you cannot Zoom and drive.
Okay, I'm pulling over right now.
Thank you. All right, could I have the parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
Raymond Martinez.
And are you Mr. Anthony Martinez? Could you unmute, please?
I'm so sorry for it.
Yes, ma'am, I am.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
All right, Mr. Martinez is here. I'm gonna say Raymond Martinez. You filed a motion to modify bond restrictions. State, have you had a chance to review the modification for bond restrictions?
We have.
Do you have any objections to the motion?
No, Your Honor.
And when I say objections to the motion, are you agreeing to lift the no contact order?
Oh, no, Your Honor. We're not opposed. We're leaving it up to the court's discretion based off the defense's motion and argument.
All right. Mr. Raymond Martinez,
Yes, Your Honor.
do you have any evidence to present to the court?
No, Your Honor, just the request to change from no contact to no harmful.
All right, and are you Amanda Medina?
Yes, ma'am.
Does anyone wish to call Miss Medina as a witness?
On the night, I know that we had.
I'm sorry, Judge, I have too much noise in the background. I'm sorry.
Does see, Brenna, men have trouble multitasking. What do I always say? All right. Miss Medina knows I speak the truth. So does anyone wish to call Miss Medina as a witness?
I would, Judge.
All right, Miss Medina, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Could you state your name for the record, please?
Amanda Medina.
All right, defense.
Ms. Medina, you understand that the court has imposed a no contact order between yourself and Anthony, is that correct?
Yes, sir.
Without getting into what happened to get us into this position, at this point, are you and he interested in continuing your relationship?
Yes, sir. We would like to.
And are you asking the court's permission to do that, whether it's through counseling or whatever other means, by changing the no contact to no harmful contact?
Yes, sir.
Has there been peace, without getting into any specifics, has there been peace since this incident occurred between the two of you?
Has there been peace?
In other words, there hasn't been any trouble, no
Right.
harassment, no.
Nothing,
fighting,
sir.
Okay. I'll pass the witness, Judge.
All right, state any questions?
No questions, Your Honor.
All right, I have a few. Ms. Medina? Again, I'm not going to get into the facts of the case, but do you and Mr. Martinez have children together?
No, ma'am.
All right, do you have any children?
Yes, ma'am, I do.
And do those children live with you?
Yes, ma'am, they do.
And were the children present during the time of this alleged incident?
No, ma'am.
All right, and what are your children's ages?
21, 16, 15, 9, and 7.
Okay, well, so where were all of these children at this time?
Asleep.
Okay. And when I say incident, again, Mr. Martinez, Anthony Martinez,
Yes, ma'am.
I don't have any facts in this case, so I will keep an open mind when it comes to the disposition of your case.
Yeah, yes, ma'am, no problem.
Now, Ms. Medina, when I mean the children present, I mean this alleged incident, when it's alleged to have occurred, were the children in the same location?
Yes, ma'am.
Okay. And has there been, are you fearful of Mr. Martinez?
No, ma'am.
And are you employed?
Yes, ma'am.
Are you able to financially support yourself without Mr. Martinez's financial input?
No, ma'am.
So is there a reason you wish to have contact with Mr. Anthony Martinez?
We've been together for 2 years, so I mean, that's a while, and I'm not just gonna give up on a relationship.
So the reason you want to have contact with him is because you're
I'd like
trying to
to.
work on this relationship?
Yes, ma'am.
All right, I see Mr. Raymond Martinez. I see that this is an assault family second. The first assault family, who was the complainant in that case? Does anyone know?
It was my uncle, ma'am.
All right, Mr. Martinez, excuse me, Mr. Anthony Martinez, you
Yes,
should
ma'am.
probably not interrupt. Let
Okay,
your
I'm
client, let your attorney answer questions, okay?
Yes, ma'am.
All right.
Judge, I don't have the information as the case is unindicted and I don't have access to discovery yet.
All right, state, what is Mr. Anthony Martinez's criminal history?
Just 1 second, I can look it up.
Thank you.
I apologize. Can I get the cause number one more time?
It's NIGhtMax 612-613.
Judges, he has 2 prior assaults. One of them was a Maria Martinez.
I'm sorry, what did you say?
He has 2 priors in Bexar County for assault. And this one was a second, and it was Maria Martinez was the complainant.
So he has the assault against someone by the name of Maria Martinez. And then the assault that he mentioned with an uncle.
That might be the, because that one was a second. There's an earlier one. Jesse. Sorry, it's not listed. I'll pull up the prior.
But the Maria Martinez, I'm sorry, the Maria Martinez, is that family violence?
Yes, Your Honor. It's a family violence ABI second.
Okay, so this is really an assault third. All right.
Fourth, because there's another ABI second in here.
Okay. All right. I'm going to deny the motion. I understand that you all may be trying to work on your relationship, but this is not the court for that. That would be a civil matter. But for now, I'm going to deny the motion. There are children in the home, young children who didn't sign up for this. And also there are other, it appears that there is more than just one assault. I thought this was just an assault family second. And when Mr. Anthony Martinez said it was his uncle, I'm assuming there's just an assault against his uncle and then the alleged assault against Miss Medina. But now I'm being told not only is it these two assaults, but there's an assault against a Maria Martinez. And I'm assuming that that's either a wife, girlfriend, or family member because their last name is Martinez. And then there's an assault that came before the assault with Maria Martinez. So that will be denied.
We have nothing further, Judge.
All right, thank you. Mr. Martinez, do you have anyone else with us?
Thank you, Judge.
All right, thank you, Mr. Martinez. I really do appreciate your patience.
Judge, I have Juan Montes, MTR.
Okay, just give us 1 moment.
You can log off, Anthony.
Okay, yes, sir.
Same thing for you, Ms. Medina. Did y'all see my chat? Okay. I think I have a little bit of a break. If y'all want to tell the judge that we have an agreement. And we're also going to reset the other one.
Yeah. Mr. Morales, could you unmute for me, please? Just look at, press the, there's a key.
Okay.
Yes.
Okay.
All right, Mr. Morales, your attorney is unavailable.
Okay.
So we're going to call you back in 3 weeks and your attorney will be here at that time, okay?
Okay. Okay.
All right,
ma'am.
thank you for your patience, Mr. Morales.
Yes, ma'am. Thank you.
Norma, can you give me the 3-week reset date, please?
Yes,
And
ma'am.
you're on mute.
Yes, ma'am. Give me 1 second. 1 second, Judge. Judge, I can bring him up on June 7th.
All right, Mr. Morales, we're going to come back on your case on June 7th.
Okay, ma'am.
All right, thank you for your patience. I appreciate it.
Thank you, ma'am.
All right. And Norma, that is 14M that can go back.
Thank you.
Yes, sir.
All right, and the other person you have,
Juan
Mr.
Montes.
Martinez?
Juan Montes.
All right, what is happening with Juan Montes?
Judge, I was just retained on Saturday on an MTR. He was arrested, I think, last week. This morning, and we're not that far apart in our conferring. Our big issue that we have is that Mr. Montes wants to make sure his animals and his belongings are secure in the off chance that he either goes to inpatient treatment, ISF, or revocation. All of those issues are on the table at this point.
All right, do you have a motion for that? Has that been filed?
I filed a motion to set bond, yes, today, Judge. You may not see it on the system because like I said, I've only been on the case 4 days. I filed it today.
All right, what we'll do then is because I don't have a copy of the motion. If you're able to come back tomorrow, we'll take your case up first thing tomorrow morning. And I'll address the bond issue.
And so I'm assuming you don't have the invite yet. Is that right, Judge, or do you have it?
I have the bond. I don't have the bond.
No, the invite for tomorrow morning.
Ms. Ferguson will send that to you.
Okay, Judge.
Yes. Thank you. Do you need to speak with Mr. Montes? Oh, you're muted.
Since I'm here, Judge, let me take advantage of that. Yes.
All right, Mr. Montez, I'm going to send you to breakout room to speak with your attorney. I'm going to send you to breakout room number 1. We're going to bring you back tomorrow, though. At that time, hopefully the motion will have come through the system and we'll hear your motion.
Thank you, Judge.
Thank you. All right, with that, everyone, we're going to stop live stream. Everyone has been so